get a defense, even what they call under a reservation of rights. Even if, for example, we may doubt that there's coverage, but we will, in many cases, defend until we get to the facts to determine maybe what the coverage issue might be. In the United States, it's commonly called, a reservation of rights. They'll defend, and it's not just used in the title industry, it's also used in a number of other insurance industries. Now, when we talked earlier about the premium and what the losses are, setting up the reserves is really an interesting issue. We feel that even in the United States, our U.S. regulators don't understand title and how to set up the reserves. When you have a policy for an automobile, it's very easy to set up the reserves. You have a certain number of policies within a year, and you know what your exposure is going to be within that year. But we are required to insure property that's probably, in some cases, 70 years old, that's never changed title. And we still have to have some formula on the books, because that property from 70 years ago can still be a liability to us. And no other insurance carrier really has that responsibility like we do. And so setting up the reserves is really challenging. Now, we have different business models that work for each of us. We issue U.S. title policies to people going overseas. People buying, one of the deals we did was a Texas Instrument plan. We insured title to the plant in South Korea, Japan, the Netherlands, and Mexico. And what was appealing to the U.S. company is that they received a U.S. title policy that follows the American Land Title Association model policies. It was an English language policy, so that if there was a claim, a coverage issue, they could litigate with us in the United States, rather than in Korea, Japan, and Netherlands, and Mexico. But if there was a claim against the property, we would hire local counsel to defend. And really, I think First American does it that way too. In a number of countries, all the competitors do it. And the big reason for doing that is because in the United States, we have a history of title litigation that lasts 100 years. But when you don't have laws in the foreign countries that govern title insurance, and in many cases, actually in almost all cases except for the UK and the United States, you have Roman civil law, which is basically not precedent. You don't have cases to read. You're litigating in foreign courts, like in Guatemala, for example, that may be very inefficient. Our court system is not always efficient, but you're comfortable in your own backyard. And so many of our clients have said, we like that aspect of the policy, and I'm sure you've gotten the same feedback from people. If it's a choice between getting a UK policy, in some cases, they would prefer to have the U.S. policy because that's what they're.
If you happen to litigate in a local jurisdiction, it might be the case that the local court says that there's no agreement. Because, for instance, in my country, in Argentina, you cannot hire insurance unless you hire it from an Argentine insurer. So you will find a situation where you will have you're pretty good in terms of the U.S. and your client in the U.S., but if you end up having to litigate in Argentina, the case would be...
Well, that's an excellent question, and I have to say that Marval in Argentina disagrees with you. The U.S. company, Marval is the biggest law firm in Argentina. Marval's legal position is as long as we are insuring U.S. investors in Argentina, we're not doing business in Argentina. If we were to insure an Argentine, we would be considered doing business in Argentina. So that's their legal opinion. Now, going to the second part of your question, if that were to happen, and I can't speak for First Title, but our company position is that we would waive that. Because if we were going, most of what we do is opinion-based. How we work in a number of countries is really structured by the opinions we receive from the lawyers in that country on what the land registration is and would our system of doing business violate the local law. First of all, the coverage issue would never come into Argentina because we would pay the lawyers to defend, and so the issue of the title policy never really comes into court. But if, and we've been asked this by clients, well, what happens if the Argentine government declares this illegal and it's a contract that's void? If I have to sue you in the United States, then are you going to raise that intervening illegality as an affirmative defense? Well, if we did that, we might as well close our shops.
Right.
There's no point in going into business if we can say that. So we've actually issued an endorsement that says that if this ever happens in a court, we will not raise it as an affirmative defense if you have to sue us on a coverage issue. But for claims purposes, the title policy never comes into play. The title policy is a contract between the two of us. All we're doing is paying to represent him in the suit he's got that maybe you filed against him to eject him from his property.
Okay.
Could you describe the affirmative defense? I know some of these legal terms, or I just didn't quite pick up exactly how.
Well, when you